parenting during the summer.
Yeah, I think we actually judged, and I apologize if I'm interrupting you. I think we agree on all the numbers. The only two issues that I think are at issue today for the court to decide.
Right out of the gate, the judge trims this down to two big issues: money and time, tax credit and summer parenting time. And if you've watched Family Court before, you know those two things are often deeply connected, because more parenting time can mean less child support. So the real question becomes, is this about finances or father-daughter bonding?
Or one, whether he does get the tax adjustment. She's traditionally claimed the child every year. In fact, I believe this case was originally filed in Seward County in Liberal and was transferred here. The journal entry actually says that she will claim the child every year. He just didn't know better back then and didn't get the tax credit when it was originally figured. But he is requesting the tax credit, and I've sent the court that, and I apologize for the late notice on that. But the credit we're requesting is 151. That's just the number that Bradley spit out, and so we are requesting that. And then we are requesting summer parenting time, and if I can, I'd like to tell the court why.
Okay.
First of all, when this case was originally brought in Liberal, both parties.
So, hang on just a minute, Mr. Hawley. So
sure.
am I mistaken that you're asking for an adjustment for the summertime too?
Yes, and that's in my Exhibit 4, I believe.
You are asking for both, an adjustment for tax and adjustment for summer if it's granted.
Yes, exactly.
Okay.
So
go ahead.
It's $113 for the summertime parenting calc. And I have that at Exhibit 4, and then it's $151 for the tax credit. But both parties are living in Liberal. The case gets filed there. Sometime in 2016, 2017, mom moves with the child to El Dorado. And so obviously the original journal entry actually said 2 weeks on and 2 weeks off during the summer. So they originally agreed to that summer parenting time. I know that one of the reasons mom is objecting is she says, well, dad hasn't traditionally done that. And that is true. He is a travel nurse by trade. And so basically, I mean, he travels all over the nation, basically, or the Midwest anyway, to be doing this travel nurse job. He has remarried, and they have 2 children together. Ms. Locke and I have both agreed to use that multifamily adjustment. Like I said, our numbers are basically the same. I think it's only these 2 issues. So he's remarried. They have 2 small children. He actually moved. He was down in Southwest Kansas for a long time, and then sometime they lived in Fort Worth for a little while. But they moved. His family moved here to be closer. In August of 2023, he moved here to be closer to his daughter. And he hasn't worked into his contract. So basically, he's a contract worker. He signs a contract for a period of time, maybe 3 to 6 months, 3 months, 3-month time periods. And he's able to put whatever he wants in there. And so he can demand that he has this 6 days work.
Next paragraph.
8 days off.
Here's where things get interesting. Dad says his travel nurse schedule used to keep him away, but now he's structured his contracts to allow real parenting time. Courts love to see effort, but they also look at patterns. So the big question, is this a true lifestyle change or just perfect timing once child support entered the conversation? Next.
And that's the way he structured these. And he uses works at night. They're starving. He can kind of terms. He works 6 days on and 8 days off. That's why we in the summertime. He'll be there for a day. Whatever you do. He believed that Locke put in her exhibits. There was July 31st last year. Basically, and he was attorney at that time. And basically, language says that he gets every week, Friday, Sunday. And this is additional parenting time that's paid by the parties van. Again, he represented that he still do his summer shared parenting time. And he had saying, and then we asked for parenting time, she said no. And then we asked why. I guess the reason was that traditionally hadn't done that. All we're asking for is $113 a month for the summer. And I know they want parenting time so that he can get the adjustment. First of all, $113 and famous words, the honorable judge, he used to make an argument about shared custody because he can lower his travel charges. That's what gives them more quality time with his kids. That's great. Policies. He just wants to spend time with his kids. 14, as you said, 15, he doesn't have a lot of that. He just wants to be able to spend time with his summer. He's quite frankly, when he had his young family, his kids are 3 and 1.5. They were trying to make money, traveling out of state, where he was getting really contracts. But now he's here, especially during the summer time period, do the 6 days on, 6 days off, 8 days off, available a week. So that's what we're $151 for the tax. She's never claimed child life in her life. And I think that's fair. I think that's summer parenting. I think that's fair to have a week parenting
I tried to there was any time where we were making adjustments because of the change of parenting time. We tried to back the whole year.
So what I did when Exhibit 4 was I just took the guidelines say more than half. It was actually that was based on child being 864 divided by 2 divided by 2 times that by 3 months gave me 1,696 divided that by 12 and that ended up being 108. But I think we'll have to figure out what child is first. That's the calculation that I use.
You don't want the amount changed.
No. That's why I analyzed it.
Okay. And so is he going to make a commitment to
paragraph. Now the tone shifts. Mom's attorney isn't arguing against dad seeing his daughter. She's arguing reliability. Family courts don't just look at promises. They look at history. And if parenting time gets expanded but never used, it can leave kids stuck in the middle while support payments drop. So credibility is now front and center. Next,
try to schedule every summer.
Oh yeah. He can tell these people. He can say this is what I demand. He can make the terms he wants.
Miss Locke.
Thank you, Your Honor. Several points that I want to address. First of all, I don't cite it in the reiteration of depending on some sort of reiteration that so I want to make sure that we filed our motion on September 4th and our asked that the retroactivity the month of filing with the guidelines. So we are asking that the child award that date of 25. My client has historically had primary residential child order with which resulted in their parenting time, but it would be consistent with the guidelines statute that child retroactive filing month to month filing. Your Honor, this has not exercised and to say that schedule time with child is simply untrue, and we can look to a break to demonstrate that. Father's Christmas was December 19th through 2027. Dad did not until December 26th because it required mom to be ready and he ended up having 26 regular schedule. Now, I don't see that modifying because she is but it is not the case that dad is just schedule the child the parent. Mom is one that's why the order since the child went straight not ready to exercise our concern is child support in order to accommodate and dad will not exercise his time. Since filed modified dad because these aren't appropriate conversations parent-child relationship. I did ask for Mr. Hall allow the orders modifying or
Paragraph. Quick legal translation moment. Parenting time adjustments affect how child support is calculated, but only if that time actually happens. The guidelines assume parents will follow the schedule. So judges often ask, should we reward a plan that might happen or wait for proof that it actually will? Next paragraph. I provided an email we believe that related to
related to the child support guidelines provide the court a lot of discretion. Specifically, Section 4, which is about parenting, because the adjustment assumes that the court may exercise deciding whether historically historically has not with the child, resulting in more time with Lily. Additionally, regarding the adjustment with the guidelines, only if there 14 or more there were automatic Judge ultimately to deny the request if the court is going to under advisement whether that is and for order today 2025.
What's your position on credit tax?
Judge, my she doesn't have a preference.
But you agree. But you agree. You should get one or the other.
Correct. We would ask that not in the 2025. He wasn't paying support. He was paying support for all 2025. Resided primarily with my client.
Okay. This athletic schedule. First of all, is a freshman going to be a freshman?
She is a freshman going to be a sophomore. She is a freshman going to be a sophomore. And she basketball, volleyball, just basketball and volleyball. Sorry.
Is this just the wait list? It's just training. They break them down for different.
I apologize.
Yeah, but they're not doing summer, are they?
They are.
That was a violation of high school.
There are certain more
Okay. Well, and it elected for the kids during the summer. Participate over the summer.
As a coach, it's optional, but strongly encouraged.
Well, there's no issue with child working to these things.
Historically judged during dad's when offered to exercise the child ended up saying was easier for dad, and so we agreed that there did have the historical pattern mom ends up spending time with dad driving back to New York.
Does mom have other stepchildren?
Yeah, two additional children.
Are they hers?
Yes.
And what are their ages? What are their ages?
2 and 4.
So they're kind of similar in both households with toddlers, so to speak. Okay.
Judge, could I just briefly respond?
Let me ask one more question. Ms. Locke, have you proffer what she might say?
I was appropriate. I could proffer what I should say, but again, I think our preference being put on one side or the other.
Mr. Hawley.
Well, I guess that was he did not fair for the child where the child choosing one parent and didn't feel like she has to at all. My client, it is true. He was taking musicians out of state, a lot of money in order to try his new family. And he does so he's now available.
And there it is, decision time. Dad gets the tax credit, and the judge approves a trial run of week on, week off summer parenting. But listen closely. This comes with a warning label. If Dad doesn't actually use that time, the privilege disappears. This is essentially a probation period for summer custody.
And I think we want to be able to spend time. They did switch. He did have to work. And they were able to switch weeks. They've done great all the time. Switching back and either one of them had a call. And with regards to start date, I would say there was an order in the original expense. He was paying for all the other sports and has been paying for until they filed And so I think that he should get the tax credit beginning when the child support starts. And we would ask October. They didn't file until September 30th. And I believe the statute does this. Even month it should start October 1st. But that's my client's position. He's available. He knows about athletics. He knows about athletics. And that'd be a wonderful time to be able to spend more time together. Thank you.
All right. Well, obviously, I'm going to get him the tax credit, and it's effective when the child support is set to commence. I'm gonna try the week on, week off, and see how this summer goes. And Ms. Locke, your mom needs to keep trasses any week. If he misses any week, forfeit the ability to do it again. And I might assess some attorney's fees or something against him if you've got to come back to court, modify that because he didn't exercise it. But I think it's important for her to have a good foundation with her as she becomes more independent, eventually be driving, might be working, might be doing sports. I think there's probably going to be less contact one direction or the other because kids from their senior year.
Paragraph. This final stretch may sound technical, but it's financially huge. Backdating support, calculating arrears, and setting payment terms determine how much money changes hands immediately. So while the emotional fight was about parents,
good framework for her to help make decisions as she becomes closer to being an adult. So I think I'm not ordering it. I'm not ordering it. I'm ordering it. I will review it. But I'm only going to do the credit, not the 50. And tax credit, of course, annualized like you did, and I'm gonna make it effective October 1. And so you also need to analyze the arrearage, and add that in to figure out how to how you want to do it, but he needs to. He's got a few months. He's got a few months. 3 months. Now to October, November, December. Actually, 4 months. 4 months. I'm actually going to make everything effective as of November 1. So he's 3 months. He's 3 months behind. He's 3 months. Actually, you need to pay that arrearage off. Okay. I think. That's it.
Judge, are you during the adjustment for January 1
Okay, well, it's going to be annualized. I would say that one starts. So you are correct.
And I think the guidelines go up to 35. I thought the adjustment was.
I'd have to look. I just took word for it.
Parenting time adjustment.
I apologize. Okay, it used to be 35. It used to be 35. It used to be 35. They did the shared. I'm too old. Okay, 30%. Okay, 30%. Okay, 30%.
Okay, if you find out something different, who has done some work on it.
I'm happy to take a crack at it.
Why don't you kind of your motion? It's kind of your motion. Yes, please. You do it. And then she can do an contract. So, but this will be paid through KBC, right?
Yes.
Okay.
So November 1st starts. January 1. I think I've got everything.
And then You guys will either keep it going by agreement, or you'll get a December of this year at the end of the year.
Judge, what if I put some language in there? Either party may file after the summer to modify that, that way you don't take calendar or anything for a review date.
That's fine too. That's fine too. That makes it more formal. That makes it more formal. That makes it more formal. Just give me a review.
Yeah, but it's also in the order. It's also in the order that the court doesn't go.
You guys have to pay every time you file a motion.
A motion to modify.
So there'd be.
Post agree. Yeah, you post agree. Yeah, you agree.
Is that like $150 or what?
Something like that. I'm just gonna give them.
I'm just gonna give them a review date, and then it stays in effect. It stays in effect unless there's a motion at some point. But I don't want him to have to pay. I mean, unless you guys stay on council like you often do, then I won't.
Yeah, I would prefer that language.
Fair enough.
Your Honor, I'd like to request that our child is being denied.
Okay. And I may next year interview the child. But I'm not going to do it. I don't do it very often, frankly. And when I do, it's usually 17-year-old kids. So I want to try it. I want to try it. This is probably going to be well, freshman to sophomore year is a pretty critical time for kids. I guess it can be part of the. So you're going to do Okay. Fair enough. Anything further?
No, Your Honor.
All right. We are adjourned. Thank you.